Good day everyone, we are the third and last group to present. Our discussion will focus on 7 articles within our legal framework. First, we will start into Article 1821 explained by Arlene Kerubin. Following that, Hazel Maydato will expand upon Article 1822 to 1824, and for Article 1825, Arlene Carabin will discuss it. Finally, I, Maria Beatriz Garcia, will walk us through the specifics of Article 1826 and Article 1827.
Article 1821, Notice to Partners. Notice to a partner is notice to the partnership. Like the law of agency, the law of partnership imputes notice to or knowledge of any partner of any matter relating to partnership affairs to the partnership except in case of fraud. The reason is that members of a partnership stand in a fiduciary relationship to one another, and it is presumed that the partners disclose to one another all relevant information concerning partnership business. Article 1821 speaks of 3 cases of knowledge. First, knowledge of the partner acting in the particular matter acquired while a partner. 2. Knowledge of the partner acting in the particular matter then present to his mind. And knowledge of any other partner who reasonably could and should have communicated to the acting partner.
Article 1822, whereby any wrongful act or omission of any partner acting in the ordinary course of the business of the partnership or with the authority of co-partners, loss or injury is caused to any person, not being a partner in the partnership or any penalty is incurred, the partnership is liable therefore to the same extent as the partners so acting or omitting to act. Article 1823, the partnership is bound to make good the loss. Where one partner acting within the scope of his apparent authority receives money or property of a third person and misapplies it. And second, where the partnership in the course of its business receives money or property of a third person and the money or property so received is misapplied by any partner while it is in the custody of the partnership. Article 1824, all partners are liable solidarily with the partnership for everything chargeable to the partnership under Articles 1822 and 1823. What is solidary liability? Solidary liability is the above 3 article provide for the solidary liability of all the partners. The requisites for liability of partnership is: first, the partner must be guilty of a wrongful act or omission, and second, he must be acting in the ordinary course of business, or with the authority of his co-partners, even if the act is unconnected with the business. The criminal liability for criminal acts is: a non-acting partner in a partnership engaged in a lawful business is not criminally liable for the criminal acts of another partner, but he is criminally liable if the partnership is involved in an unlawful enterprise with his knowledge or consent. Misapplication of money or property of a third person. The partnership is liable for any losses suffered by a third person whose money or property is misappropriated by a partner who received it within the scope of his authority or by any other partner after it was received by the partnership in the ordinary course of business while in its custody. Sinabi sa Article 1824 na kapag nangyari is wrongful act or breach of trust, solidarity obligation ang magiging effect niya. In Article 1816, na-discuss doon ang provision kung saan magiging liable din ang mga partners and partnership, pero difference siya sa Article 1822, 1823, and 1824. Sa Article 1822, 1823, and 1824, ito ay solidarily liable and civil liability of the partnership that arises from the wrongful acts or omissions of any partners. In Article 1816 is yung liability na magkakos or lalabas from the article is joint and subsidiary liable, meaning pro rata. Yung mga liability lang ng mga partners and partnership is, in this case, is kung ano yung share nila, yun lang ang kanilang liability. And yung pwede lang nila i-ask for demand for fulfillment is kung ano lang yung share nila. Kung ano share mo, Yun lang ang liability mo, and this is liability arises from the contractual obligation. Sa Article 1822, 1823, and 1824, ang sabi dito is solidarily liable. Hindi na siya jointly or subsidiary, gaya ng napag-aralan natin na obligation and contracts na ang solidarily liable or liability says that each debtors, in this case, the partners or the partnership, each of them is liable for the whole obligation. Hindi na sa as to their shares, but rather as the whole obligation na. And the creditors in this case is entitled to demand the fulfillment of the whole obligation that is solidarily liable. As compared in Article 1816, mas mabigat ang responsibility ng isang liability or degree of liability when it comes to Article 1822 and 1823. And 1824 because this has caused from civil liability of wrongful acts or omissions. For example, A, B, C. These are the three partners, and X is the third person. Ngayon, for example, si A, siya yung may wrongful omission, and nangyari to in ordinary course of the business. May nasuffer na damage si X. Si X has the right to claim against all of them, not just A. All of them. Yun yung nature ng solidary liability. So dito sa 1824, yung damage suffered by X even A is the guilty person or partner can be collected from C and B. Pero si B and C being the innocent partners can always ask for reimbursement from A. Again, the Article 1822, 1823, and 1824, this article pertains to resulting a receiving liability from the acts of the partner. It pertains to a civil liability resulting the acts from the partner of partnership or partnership that resulted to a harm, loss, or injury to other person, causing damages, and such damages becomes the liability na kailangan nilang bayaran. In Article 1822, nag-cause na ng loss or injury, meron ng damages na kailangang bayaran, ito ang magiging liability or civil liability, while in Article 1823, the partnership is bound to make good the loss, kailangan daw is bayaran yung damages na naikos niya. Lastly, the Article 1824, all partners are liable solidarily with the partnership for everything chargeable to the partnership under Articles 1822 and 1823. Liability arising from partners' wrongful act or omission or breach of trust, nagkukos ng liability ang any wrongful act or omission which is Article 1822 that wrongful act or omission cause loss or injury to third persons. Article 1823, it pertains to misapplication of asset entrusted to a partners or partnership. Ang tawag sa kanila is solidary obligation, liable si partners and partnership.
Article 1825, Partnership by Estoppel. When a person has been thus represented to be a partner in an existing partnership, or with one or more persons not actual partners, he is an agent of the persons consenting to such representation to bind them to the same extent and in the same manner as though he were a partner in fact, with respect to persons who rely upon the representation. When all the members of the existing partnership consent to the representation, a partnership act or obligation results, but in all other cases, it is the joint act or obligation of the person acting and the persons consenting to the representation. Persons who are not partners as to each other are not partners as to third persons. No one can be held liable nor claim rights as a partner unless he has given his consent to become such. An exception to this rule is Article 1825. Due to the doctrine of Estoppel, one may become liable as a partner even though he is not a partner in fact. A person may, first, represent himself as a partner of an existing partnership with or without the consent of the partnership, and lastly, represent himself as a partner of a non-existent partnership. If a third person is misled and acts because of such misrepresentations, the deceiver is a partner by estoppel. If the partnership consented to the misrepresentation, partnership liability results. This gives rise to a partnership by estoppel with the original members and the deceiver as partners. If the firm had not consented, no partnership liability results, but the deceiver is considered still as a partner by estoppel with all the obligations but not the rights of a partner. Hence, the holding out as a partner may be done by the person himself or by his consent or with his knowledge. To hold the party liable, the third person must prove such misrepresentation by the purported partner and that a bona fide or justifiable reliance by him upon it caused him injury.
Article 1826, a person admitted as a partner into an existing partnership is liable for all the obligations of the partnership arising before his admission, as though he had been a partner when such obligations were incurred, except that this liability shall be satisfied only out of partnership property, unless there is a stipulation to the contrary. Article 1826, ang kailangan tignan dito sa Article 1826 is yung timing. For example, at this time, ang obligation ng partnership ay 80,000. Ang partners pa lang is si X and Y, while si Z, naging partner lang siya nung may 80,000 na obligation. Meaning, naabutan na niya yung partnership obligation na yon. And then also, at that time, yung asset nila ng partnership is, let's say, 40,000. And then, si Z, nag-contribute siya ng 20,000. So, ang total na partnership asset ngayon is 60,000. Pero ngayon, yung pinagkakautangan nila ng 80,000 na, let's say, si A, naghabol na siya, hihingi na siya ng bayad. And kinuha na niya yung asset na 40,000 as well as the 20,000 additional capital contributed by Z upon his admission to settle down, pero kulang pa ng 20,000 to satisfy the 80,000 partnership obligation. The question here is, kanino niya ngayon hahabulin yung 20,000 na kulang niya? Yan ay habulin niya kay X and Y lang. Hindi kasama si Z dahil nakalagay dito na except that his liability shall be satisfied only out of partnership property. Hanggang dun lang yung ibabayad niya. If naabutan na niya yung partnership obligation at that time of the admission na. But if it is incurred after the admission of Z into the partnership, then the creditor, if hindi mababayaran yung partnership obligation, can run after the personal property of X, Y, and Z. Damay na siya dun. Damay na siya dun sa obligation na yon. Pero yung mga naabutan lang yan na obligation upon his admission as a part of the partnership, up to the extent of his contribution lang ang kanyang obligation. Except, of course, dito sa dulo ng provision, there is a stipulation to the contrary. Pag nag-usap-usap sila upon admission of Z na, o sige, tanggap ka na dito ha, o may utang kami 80,000. At pag hindi tayo nakakam up ng sufficient na pera para bayaran yan, then magiging personally liable ka to the extent of your personal properties. Then kapag ganun, so be it. Pag pumayag siya. Pero kung walang ganong klaseng agreement, the liability of Z will extend only to his capital contribution for those obligations na nabutan lang niya upon his admission as a partner to the partnership. Okay, let's move forward to Article 1827. Article 1827 is just the repetition of other principles that have been already discussed. Kapag may partnership property, sino ang mauuna dyan? Siyempre, yung creditors of the partnership. Kung sakaling nagkaroon ng problema yung partnership at sa tingin ng mga creditors, nalulustay na or nauubos na yung partnership property, mag-uunhan na yung mga creditors niyan. So, with respect to partnership property, yung creditors ng partnership ang unang kukuha kasi sila yung preferred pagdating dyan. Kung ang pangbayad is ang partnership property, ang unang babayaran is the creditor of the partnership. But if it is a personal property, syempre, ang uunahing bayaran is yung personal creditor ng concerned partner, hindi yung creditor ng partnership.